Good evening. This is Laws 11046. This is environmental law, and my name is John Milburn. Tonight we're talking about environmental impact assessment, protection, conservation management, pollution, and a few other issues. But before we start, a couple of things. The first is that you would be aware that there is now the opportunity for you to provide feedback. The university does want to encourage students very much to provide feedback. It helps us to provide an enhancement to the overall design of the course, the way it's delivered, the outcomes, and all of this is considered very carefully by the university. We of course want it to be a positive learning experience. We want to ensure that you are taught so that you can reach your potential, and we want to meet certain outcomes. The courses should be designed, are intended to be designed to develop appropriate knowledge, skills and attributes that are needed in your practice once you complete your studies. It's important that from my perspective I provide you with clear indications of what I expect, and that should be communicated to you on a regular basis. Very importantly, the learning within this course is intended to be collaborative, and students should be actively engaged and encouraged to participate. So that's what we've tried to do through Zoom sessions and UCrew, and to a lesser degree Moodle, but I encourage you to continue with that process, particularly as we go towards assignment number 2 and we draw towards the examination. So if you haven't been involved in study groups, I'd urge you to do so now. The assessment is designed to allow you an opportunity to demonstrate that you have acquired the necessary knowledge and the skills and the attributes that we expect of you. What I will do is post a video from Professor Scott Bowman, the Vice-Chancellor, in relation to the importance of the evaluations and why we encourage that to be done. Now, the main topic for tonight is a matter of environmental impact assessment, and what I'm going to do is encourage you to look at a video which was prepared by an environmental scientist, Mr. Phil Jeston. That was prepared last year. I have uploaded it to Zoom, and it's a really important video in that it provides a very practical aspect to the preparation of environmental impact assessments. And so often you really need to speak to practitioners in the field to enable you to understand how these things work in a real sense. And that's what I'm trying to do as part of assignment number 2, not to do with environmental impact assessment, but just try to make it very real and practical. So I'd encourage you to have a look at that video by Phil Jeston, which you'll find in week 10 of the course. Phil is from GHD Australia, Business Group Environment. He's based in North Queensland. He has more than 16 years in experience in environmental management, including auditing, developing, managing systems, obtaining approvals and assessment of environmental projects. He's been involved in some large-scale projects, has written many of those assessment pieces that are required, and is very experienced. He's also a published author for QUT and the Queensland Environmental Law Association publication. So as well as reading the material in relation to environmental assessment, I would urge you to watch that video by Phil Jeston. And that's one of 3 videos which relate to, or 4 videos really, that relate to the way in which what we do theoretically is meant to be applied in a practical real-world sense. The others in the series, well, you would have been aware of the video with Rod Litzter QC, where he spoke specifically about the Predajon case. And I hope you didn't put in your assignment without having first considered very carefully that video. Then of course, we have the video by Roger Curry, who is a community litigant, a scientist as well, and he has spoken about his experience in terms of taking on the big players in environmental litigation in Queensland. He was very much involved in issues to do with the Traveston Dam, for example. So I'd ask you to really carefully watch that video as well. And finally, from a purely legal courtroom etiquette perspective, we have the video involving Judge Morzone QC, who was Dean Morzone QC at that time that we did the video last year. So he's now a judge and very knowledgeable in terms of environmental law as well. Okay, so there's some real life practical issues that we want you to look at. To assist you in terms of the exam, I'm going to, over the next few weeks, provide you with some more hints in terms of what I expect. But what I will say tonight is that the exam is going to be open book. Now, what that means is that you can take in your textbook, you can take in law dictionaries, you can take in study modules, you can take in your own typed notes. What I would suggest you do is, if you think you can guess what the question might be, why not write your exam? You'll have to rewrite it, of course, in longhand, but there's no reason why you can't take in your own typed notes. The exam, so pretty much you can take in anything you want, apart from anything which will give you access to the internet or a standard dictionary or a calculator. You won't need the calculator as a calculator, but you can take in everything else. Don't take your phone into the exam room, otherwise it'll show up in academic disciplinary issues, so just leave that in the car or at home. So make sure that you don't have anything which could possibly give you access to the internet. But otherwise, prepare your answers in a lot of detail, and in some ways you can treat it as an assignment piece. The exam will be not only open book, but it will be essay based. And if you haven't looked at last year's exam, which I wrote, I'd urge you to do so, because, and this is a huge tip, it's not going to be that much different in style. It'll be very similar in style, and who knows, maybe some of the content will even be similar as well. So I think you've got an idea, if you've been watching me each week, of the things that I'm trying to stress throughout this course. Okay, so that's the exam. I will post a few videos which might provide you with some tips as well. So I'll post those both on Moodle and in UCrew. All right, now let's talk about assessment number 1 and assessment number 2. Firstly, assessment number 1. I was generally very happy with the results, and thank you very much, everyone, for providing your marks and your feedback, and your commentary through that assessment. Now, in that case of Predajon, what I wanted you to do was consider and interpret a decided case. So we were kind of looking at the way in which a dispute finishes, that is, with the judge considering all the evidence and writing a judgment. So the purpose of the exercise was looking back to consider and interpret how that case was decided, what was deemed to be important, how the judge dealt with the evidence, etc. And it was all done from the perspective of a planning and environment court dealing with an application against an adverse decision from a developer's perspective. So that's what that case was all about. Now, assessment number 2 is partly theoretical, dealing with the precautionary principle, but partly very practical in dealing with this case, which is the Fraser Coast Regional Council against Byrne Brothers Pty Ltd. Now, the thing you'll notice about this case, of course, is that it's not yet decided. So you can see that the way I've tried to structure the course is pretty much working backwards. Let me explain that in more detail. You'll recall that we started the course in very broad spectrum. We were talking about the way in which environmental law is sourced at an international level, at a national level, at a state level, and how the various planning instruments filter down through to local government instruments. We also talked about the separation of powers between the judiciary, the executive, and also Parliament. So we've got the bigger picture, and what we've been doing through the assessments is trying to narrow down further and further until we're becoming quite specific. We've also been working backwards. So what I wanted you to do was consider both a decided case and some legislation that was already in existence and comment upon that. Then we've gone back, and now we're at the stage where we're talking about something that hasn't even been completed. So in a sense, in looking at that case of Fraser Coast Regional Council against Byrne Brothers, I'm asking you to make commentary in relation to something that's real time, real life, in relation to a current undecided case. So previously you had to look at a concluded case, you looked at what had been decided by the judge. Here, you're partly taking the place of the judge and partly taking the place of the advisors to the litigants. And what you need to do is consider where we're at now and think, amongst other things, how did we get there and what's going to happen in the future. So I'm asking you to postulate what may happen in the future. In that sense, I'm asking you to consider it from the perspective of, if you like, the judge, but also how we present the case. It's a difficult exercise in that the parameters are quite broad, but the intention is to drop you into a real life situation and say, okay, what's going to happen now? What do you need to do in order to advance this case? So you can look at this exercise from the perspective of advising one of the parties, or advising both of the parties, or considering what you think the parties might do, and then postulating what you would do as the judge in terms of deciding it. Or, and this is what I'd recommend, you consider it from all three perspectives. So it's really quite broad. Now, the reason that we're doing this is that I want you to, working back, okay, we now see the big picture in terms of theory. We've looked at the legislation. We've got an idea of the legislation both at state and federal level. We've now looked at how cases are decided, so we're becoming narrower and narrower. Now we're thinking about the evidence that's to be presented. So tonight we're talking about environmental impact assessments, the environmental impact statement, which is all part of the material that's presented for the decision maker to make. The case hasn't been decided, but we're asking ourselves what would be necessary in order to get this development approval, or what would be necessary to stop this development from being approved, looking at your different perspective. And that's where something like the environmental impact assessment process is vitally important in terms of its evidentiary value. But we go back further and we think through this exercise involving Fraser Coast. Okay, how did we get here? What do we know about this case already? And what would we do? How would we go about running this case in the future? And it'll give you an opportunity to provide your comments, and then perhaps in a year's time you could go back on the website and see how it actually finished and see how you worked out. Remember in week 1 I said that one of the beauties about law is that there's no definite right or wrong answer, and that it's the way in which you identify the issues and argue the case that is really important. So when it comes to dealing with question number 2, that is dealing with Fraser Coast against Byrne Brothers, maybe the way to consider it is to think right back when we talked about how lawyers think. Remember we talked about the IRAC method, or MIRAC, which is the one I prefer. We're trying to identify M, the material facts. What are the factual issues that are really important to this matter? What are the facts that matter? What are the facts that we don't care about? The facts that are of no consequence. The fact that it was a nice, bright, sunny day probably doesn't matter. But the fact that someone was apprehended in the course of doing something which had environmental ramifications may matter. So identify what the material facts are. Then next we need to identify what are the issues. What are the main points? What are the actual issues that we're arguing about? Who cares if it's this or this or this? That doesn't matter. But these are the important issues. These are the things that really we need to consider and argue about. So that's the I in the MIRAC process. The R in the MIRAC process is the rules. So what are the important rules? Should we consider international law? Should we consider Commonwealth law through the EPBCA? Should we consider state law in Queensland through the Sustainable Planning Act, or perhaps the Environmental Protection Act, Vegetation Management Act? What are the relevant rules? Now, those rules probably will be statutory rules, meaning from a statute, but the rules may come from case law. So you'll recall back when we talked about where our environmental law comes from, It comes from statutes and it comes from case law. And you recall in the Predajon case, Judge Everson in that case had to weigh up aspects of the Sustainable Planning Act, had to weigh up aspects of the Integrated Planning Act, the Cairns Regional Plan, planning policies, etc., which were all sort of statutory or executive, but also weighed up 3 cases, Waitman, Polaris, and a few other cases that had a bearing. So the rules that you may consider in this Fraser Coast Council against Byrne Brothers may be statutory or they may be case-based. Okay, so material facts, the issues, the rules, then we get to the interesting part. How do these things, how are they applied, which is the A in practice? How does the law become applied when we consider the material facts in the context of this case? So look at the application that may be in existence already, or you may have to argue it or postulate in relation to how the rules will be applied in these particular circumstances. And then finally, C, conclusion. Well, nobody knows yet because the case hasn't finished. So here's your opportunity to write the ending. You can be your own journalist, you can be your own author in terms of a thriller. All right, so that's what I see as being the point of the exercise in assessment number 2. We're working back from that big picture, and now we're right down at the stage where people are looking at us, the finger's pointed at you. What are you going to do about this case? What are you going to decide about this case? There is no answer. You have to write the ending. All right, now, are there any questions about what I've said? Because I've been talking for a lot. Nothing yet? Okay, I'm getting some thumbs up. All right. If there are any questions, please feel free to interrupt or just ask through the chat facility. Look, I should give you some guidance as to the way in which I look at marking. I suspect it's probably very similar to the way most course coordinators look at it. The first thing is, and I hate to say it, and may be regarded as being a bit superficial and shallow, but the way in which the paper is presented is really important. So if you haven't done so, look at my sample document. It's not the most beautifully presented document by any means. I've had many students who've presented far more professional looking papers, but be consistent with your presentation. It really irks me when I see misspelling and poor grammar, particularly when it's so easily identified, because you get those little green lines, or you get the little red lines, or you get the blue lines, and if you get one of those things, just fix it. Secondly, make sure your font is consistent throughout. Sometimes I get papers which are presented partly in Calabria 11, then suddenly the font goes to 12 and then back to 10, and sometimes the font changes to Times New Roman. You think, why did that happen? And sometimes people have left Justify and then they go to right Justify all of a sudden. And do you know what I think? I think to myself, well, obviously someone must have cut and pasted something, because that's the way it looks. Because if you're just continuously typing, the machine isn't going to change font. It's going to not change the presentation. But if you cut and paste something in and you don't adapt it to the style that you're using, it's going to stand out. So it looks pretty bad. And if you're charging $400 an hour as a consultant to a developer client in an environmental law issue, and you're presenting your paper and it looks terrible, then the client's not going to be very impressed. So present the paper well. Other than that, in terms of assessment, I like to see that you have a good understanding of what's being asked of you, a good understanding of what you've read. The way I ascertain that is through the feedback that I get from you. So you make a statement and you draw a conclusion from it. Then I know that you've got a good understanding of what you've read. I like people to read widely, and you're very wise, of course, if you make reference to the fact that you've read widely in your material. I know that I've indicated that referencing is not something that I'm overly pedantic about. Provided you've referenced, I don't care so much how, but you probably know that I do have a preference for referencing through footnotes, because that's what we're trained to do, and that's what you see in the textbooks, and that's what you see in the case law primarily. If you don't know how to use footnotes through Word, it's dead easy. And it really irks me when people don't know how to do that. And if you don't know how to do that, you probably need to do a little course in Word. But I'm probably talking to the people that know these things much better than me in terms of how to use programs. So apart from that, I'm looking for the way in which people write. Is it in an effective manner? Have they drawn the appropriate conclusions from the case in their comments? Have they come up with something that might be interesting, or a good approach, or some sort of novel idea or argument? Have they come up with a style of writing or presentation of writing that makes it easier for the reader? Look, if you don't use short sentences, particularly at the start, you're at a disadvantage. Some of the best papers that I write provide a left field, sorry to use an Americanism, approach to the opening paragraph. So when you're talking about the Preterjohn case, you know, it might have been tempting to go straight in and say, this is an appeal against a decision of the Cairns Regional Council in relation to an application, blah, blah, blah. That's all fine and it's all very factual. Or you might approach it with an eye-catching, attention-seeking opening, something like, once there was a beautiful headland north of Cairns that was used by people as a dump, and someone came along with a vision to change it. You know, I'm just making something up, but just something that is kind of going to draw the reader in, so you think, oh, this is a bit interesting. I better have a look at this, rather than something that's very clinical and dry. And as you would have seen in my sample document, the way in which Lord Denning used to open his comments in cases just compelled you to keep reading. Short, sharp sentences, painting a little picture, draws you in. Apart from that, some of the best students use pictures, they use pictorial guides, they use graphs. Be inventive, show that you've got some different ways of thinking about the assessment piece. And of course, we're looking for people that actually get the right answer and can argue the right answer as well. All right, so I hope that's given you some indication of what at least I look for when I'm marking an assessment piece. All right, so no questions yet. Everyone's happy? No one wants to ask any questions? No comments? All right. Look, let me continue. I want to talk, I have to be fairly brief now, but environmental impact assessment. That's the main focus on this week's reading. So read the commentary. You'll see that I've got a Zoom session loaded on as well. Environmental impact assessment, and read and have a look at what Phil Jeston said as well. Environmental impact assessment is mostly required through legislation. And of course, the idea of imposing a requirement to have an EIA or an EIS, which comes from it, is to enable the decision maker to have proper information so that that decision maker, whether it's an assessment manager or a court, can truly consider what the impacts might be on the environment in relation to a proposed development. That's clearly the aim, to provide the decision maker with assistance. That's why we do the EIA. In other words, the environmental impact assessment or statement is not a conclusion in itself. It's simply something to assist the decision maker. Because we are governed initially by legislation as the primary source of our law, and then to a lesser degree, case law, we need to bear in mind that when the environmental impact assessment is prepared, the report writer must always keep the principles of ecological sustainable development foremost in his or her mind. That's ultimately what the court will be looking for, a decision which is correct based on ecological sustainable development issues. Excuse me. The person who draws the environmental impact assessment should be careful to consider the impact on the environment now, but also provide or proffer suggestions as to how any potential damage may be mitigated or how any potential damage may be monitored and managed into the future. So that's also part of an EIA. And it comes as a result of considering all of those things that ultimately the decision maker will consider what the public have to say about the matter, and the public are invited in that process, sometimes in terms of participating in the original terms of reference, but also in the ultimate EIA itself, which is normally prepared and presented as a draft, pending the input from third parties. The EIA process is required by statute, both at a Commonwealth level through the EPBCA and also through state legislation. It might be different types of legislation. But to avoid the necessity of having to do both, the state and federal governments entered into what are called bilateral agreements. And what that means is that state government agencies can be accredited to undertake the assessment process, which will comply with both jurisdictions, that is both federal and state. The other thing is that there are a number of criticisms which are levelled at EIAs. Obviously, developers sometimes think that they cost too much and they take too long, but they are a necessary part of the regime now, particularly when one considers, and this is a bit of a hint for the assessment number 2, that the precautionary principle is now something which is very important in the way in which decision makers go about making the ultimate decision. And of course, precautionary principle is part of ecological sustainable development, but it's a very important part. Okay, so the EIA process can be specific for certain aspects of a proposal, or it can relate to every part of the proposal. Now, those of you that have already seen that video involving Phil Jeston will be aware of the potential cost associated with preparing an EIA. And we're not talking hundreds or thousands or tens of thousands, but we're talking hundreds of thousands and millions of dollars to prepare one of these things. So, you know, when we talk in a theoretical context about environmental law, it's just so easy to ignore the reality that these things are huge in terms of their importance and what they do. So when you're studying things like EIAs, think about what this really means to the parties in terms of the cost, the time, the risk. It's huge. And again, that's part of why I want you to have a look at this thing with Byrne Brothers, just so you get a real feel for what it's really like, is what I'm trying to get at. Okay, so these environmental impact assessments, as you'd probably be aware, they're not paid for by the government or government agencies. It's up to the proponent of a proposal to prepare these things, so it comes again at a huge cost and risk. What I would suggest is that if you're involved in advising people in preparing an EIA process, or in fact if you're preparing the EIA, you might want to spend a lot of time in organising the terms of reference. And that terms of reference is, I suppose, a way to identify what are the appropriate criteria which need to be considered in that assessment process, what is the appropriate methodology to be undertaken in that process, and it's something that is best done collaboratively with the ultimate decision maker, with the assessment manager and the public, if you can, to a degree. So the public can have a great say in this process. For example, and you would have seen this in Roger Curry's video, the Traviston Dam proposal, where the terms of reference and the actual EIA and the environmental impact statement that came from that was very heavily influenced by what the public had to say. All right, well, I'm getting very close to the end. Just before I finish off, there's nothing on the chat facility, no questions yet. All right, so just finally, EIAs, They deal certainly with the environment. That's the primary reason. But bear in mind that you need to consider the Act. And when we talk about ecological sustainable development, we're not just talking about the environment, we're also talking about the social and the cultural and the economic. So the EIA should deal with all of those things which are important for consideration by the decision maker, and don't be blinded by the word environmental in EIA in terms of it just being for the environment. It's meant to be much broader than that. All right, so from a practical point of view, once the EIA is presented, considered by the assessment manager, from a proponent's perspective, you hope that your proposal will be approved, but it's not just a matter of approving the proposal. Bear in mind that the big argument might be about the conditions. And I think Phil Jeston makes comments to the effect that sometimes the decision makers can impose conditions that are so onerous that it's effectively tantamount to a refusal. So it's not just necessarily getting the approval, but getting the approval on appropriate conditions, which is something fundamentally important to the proponent of a particular development. Okay, so no questions. All right, so next week we'll be talking about Bates chapters 6 and 10. Hi, Anthony, have you got a question?
Yeah, I've got a quick question about question 2 of the assignment 2.
Yeah, sure.
Just in regards to giving an overview of the case, do we reference an affidavit?
Absolutely, yes. Reference the affidavit and the paragraph number from the affidavit.
Right.
Either if you're quoting from it or if you're summarising or paraphrasing it. Absolutely.
Right. No
and
worries.
2 reasons for that. The first is, and it's a great question, thank you very much. The first reason is that you are, as always, appropriately referencing some external source. But also, it provides the reader of what you have to say an opportunity to go back and look at that original source. So, absolutely.
Yeah, thank you.
Okay. Any other questions to do with that or any other assessment piece or other issue? All right. So next week, chapters 6 and 10 is what we're talking about, environmental administration and management. And then we'll deal with environmental litigation and ADR. Week 12 will purely be by way of review so that we can recap and talk about the exam primarily. I'd really like people to become more active in UCREW. I think this second assignment is a really good chance to collaborate. Don't worry, nobody's going to get pinged for collaboration in terms of exchange of ideas, but I'd really like to see some good exchange of ideas, and already there has been some good exchanges in UCREW. If you're not in UCREW, you definitely enrol, even though it's the last few weeks. Have a look at it, make sure that you understand it and participate. All right, now, are there any questions here? Okay, with question 1, there's a question here. I'm confused about as applicable in Queensland. All right. Oh, yes, okay. So question 1 of assessment number 2 is, with reference to relevant legislation and case law, outline, describe, critically appraise the effectiveness of the precautionary principle in environmental law as applicable in Queensland. Now, that doesn't mean that we only talk about the Queensland Act. We talk about any aspect of the law which is applicable in Queensland. Now, that might mean international law is still applicable in Queensland. Commonwealth law through case law, etc., that can be applicable in Queensland as well. So I'm not just talking about the precautionary principle as it may or may not be referred to in, say, the Sustainable Planning Act, but there's no reason why you wouldn't talk about the EPBCA or perhaps international treaties. And look, if you're not in Queensland, don't hesitate to simply adapt that to your state or territory, because I'd like you to learn something that's relevant to you. And if you happen to be in New South Wales, then by all means apply state law as it applies there. But in doing so, and I hope this is answering your question, you're not just talking about the state statute. You're talking about the law. So, you know, when we talked about Fraser Coast and Byrne Brothers, the second one, I said, well, here's your chance to think about the law. Does the international law apply in this case? Does the federal law, does the state law, the case law apply? So whatever you perceives the law to be, then that's what you should talk about in the context of the precautionary principle. That's a really broad question, and that's a great question. I hope that I've answered that appropriately. Are there any other questions, comments? Hopefully that's resolved any confusion about what is meant by as applicable in Queensland. Okay. All right. Well, if there's nothing else, I'll stop the recording, and thank you very much for watching, and we'll see you next week. Bye.